Well, we'll go ahead and get started. Thanks everybody for joining us today. My name is Lisa Hassenstab. I am the Public Policy Manager for Disability Rights Wisconsin. DRW, along with Board for People with Developmental Disabilities, kind of co-facilitate the Disability Vote Coalition. And DVC is who is hosting this webinar. So thanks to everybody for joining us. This is an issue that we hear a lot about, and know that there are a lot of questions, there's a lot of complexity. And so we have brought some experts in to kind of go walk through some of the processes and some of the information that we hope will be really helpful for folks. We invite you to use the Q&A to submit questions, and we'll try and attend to those um, throughout the presentation. We will have some time reserved at the end also to dive into some of those questions if we haven't had a chance to review them during the presentations. We unfortunately had a couple of panelists that weren't able to make it due to some emergencies. So we might have to pivot a little bit, but we won't, there's no lack of information for us to share. So we'll do our best to make sure that we're covering all the information that we think will be helpful. And then welcome questions. And we are always available to answer questions that you might have outside of this time as well. I will we'll share information too about the Disability Vote Coalition. For those who don't know, it is a coalition of organizations, nonprofit organizations, self-advocates, other entities who are just interested in supporting the right of individuals with disabilities to participate in the electoral process. So that includes a whole bunch of different stuff. We are really excited to have upcoming in about 6 weeks the Disability Voting Rights Week in September. So we've got some exciting stuff planned for that, and have a lot of great information to share as we head into a busy election cycle. So with that, I am going to turn it over to Jessica. And Jessica, if you would be willing to just do a quick intro of yourself. I apologize that I don't have one with me right this second, as we've been trying to kind of sort through some of these last minute changes. So if you'd be willing to just let folks know who you are and a bit about your background, and then I invite you to dive into the content.
Thank you, Lisa. Everybody can hear me okay? Okay, great. So I'm Jessica Liebau. I am an attorney. I'm going to be going through sort of the legal aspects of some of this. I work for a law firm called Wessels and Liebau. We have offices in Mequon and in Sheboygan. I've been doing guardianship work. I actually started interning with some of our legal services agencies when I was still in law school. So I've been doing this a long time. I've been an attorney for 15 years now. And when we talk about guardianship and voting, I help people get guardianship. I help people terminate guardianship. I serve as GAL. I've been involved in a lot of these cases. So I'm really excited to be able to present today, and to sort of trade knowledge. Lisa helped us out recently when we were trying to train guardians ad litem on the rules related to voting. She came and presented to us, so I'm happy to repay that favor. Um, and starting this fall, I get to be a poll worker for the first time. I've never gotten to do that before. So I'm sort of a voting nerd. I really think that all the information that's in here is information everybody should have, and it's really not that well known. There's a lot of things that people don't understand about this process. So the goal in the next, 15 minutes or so that I have is to hopefully everybody will have a little bit more information by the time they're done about how this process works. So I know there was a PowerPoint. I don't know if that PowerPoint is going to be loaded or not, but I'm going to go off of the material on that. I know that it will be provided after the fact if it isn't loaded on here now. So if it shows up, great. Otherwise, I'm just gonna I'm going to do some talking and try to make it easy enough to understand, and then you'll get the written information afterwards. So I know, the Wisconsin Disability Vote Coalition, they have some great guides and paperwork as well. But we're going to focus specifically on, even though I could talk about this for hours, specifically about the basics of guardianship and voting in Wisconsin. And keep in mind, this is very state specific. So if you're from another state, they could tell you something totally different, and they might be right too. But this is how, oh, there it is. See, ask and you shall receive. Um, so when we talk about guardianship in Wisconsin, what guardianship is, in its simplest form, is a court deciding that somebody needs somebody else to help them with certain decisions. A guardian is appointed for somebody when the court finds that they are incompetent to do certain things. We do not have the type of guardianship in Wisconsin where a guardian is just given the ability to do everything for another person, for the most part. Our guardianship law is designed to be very specific according to what somebody needs. So we have guardian of the person and guardian of the estate. Now, no matter what sort of guardianship we have, a guardian never has the ability to vote for another person. And just because you are under guardianship does not mean that you can't vote. It all depends on your particular guardianship case. So when we talk about guardianship, that itself does not say anything about whether somebody can vote or not. And as this slide points out here, if you have a guardian of the estate only, which means somebody was appointed to help out with your finances, with your bills, with your money, that's not a situation where the right to vote is ever removed. If you have a guardian of the person who's supposed to be helping out and making certain decisions related to personal decisions, you may or may not still have the right to vote. Can we move to the next slide, whoever is controlling that, or do I have the ability to control that myself? I don't think I do. All right, well, I'm going to keep going. So with a guardian of the person, they are handling personal decisions. Things like health care, education, where you travel, where you go to school, where you live. A guardian may be helping out with certain things in that regard. The way that you know whether a guardian has certain rights and what rights they have is a piece of paper from the court that's called a determination and order. So if somebody comes to my office and they say, I have a guardianship, or a parent comes and says, I have guardianship for my kid, that doesn't tell me anything until I actually see the determination and order. Because that's the piece of paper that says, did this person keep the right to make their own travel decisions? Did they keep the right to get married? Did they keep the right to vote or not? So it's called a determination and order, and that's the piece of paper I'm looking at. So if somebody comes to my office and says, I want to know if I can vote, I am looking at that paperwork. So in terms of keeping your right to vote, we should all know that it's a constitutional right. So if you are old enough to vote, it doesn't matter what your disability is, you have that right to vote unless it has been restricted by a court. So, oh, can I click on it now, maybe? We'll see. Okay, they're clicking ahead for me. Great. Sorry for everybody who's just listening. I'm just trying to keep up to speed here. So we talked about this slide. So then the next slide is about keeping your right to vote. Perfect. So if you have an activated power of attorney, that does not take away your right to vote. If you have a supported decision-making agreement, that does not take away your right to vote. If you have a certain type of disability, none of those things take away your right to vote unless a court has done that using a very specific process and signing off on very specific pieces of paper. Okay, next slide. Okay, so the reason we're talking about this is because a lot of people do assume, and we hear this in the news and with politicians and with people who have good intentions, they equate guardianship with not being able to vote. Guardianship is a question that comes up, or voting, excuse me, is a question that comes up with guardianship. But the reason it's important to know your rights is that when it's in the court, there's a judge or a commissioner making a decision. And you need to make sure you know what your rights are so that the judge or the commissioner is making the right decisions when it comes to that voting question. Next slide. So, if we're not part of a guardianship process, then that question doesn't come up. Um, it is always important to make sure that we're only using guardianship when we need to. We know some people really do need some form of guardianship. So we're not avoiding guardianship under any cost. We just need to make sure it's appropriate. So this slide talks about, if you just want somebody to be able to get information on your behalf, that might just be release forms. Um, if you want somebody to be able to make decisions, if you need help with those decisions, that could be a supported decision-making agreement. If we're dealing with Social Security, that could be a representative payee. If we're talking about either medical or financial things, it could be a power of attorney. Those are all sort of things where the person with the disability still gets to keep a lot of control, and we're not actually taking any rights away. But guardianship often is needed. A lot of people who are under guardianship, it's there for a good reason because they really do need the court to appoint a legal decision maker. And in that process, there are some rights that can be limited or shared or removed. So we always want to try the least restrictive measures first. But if we get to guardianship, then that's where we need to make sure that we're looking at the voting question in the right way. Next slide. Okay, so courts, when we're dealing with guardianship, there's a lot of really confusing paperwork. But we start out with when somebody is petitioning for guardianship. The way it works is a petition is asking the court to appoint a guardian. If a guardian's appointed, then you end up with that order that I talked about. So it starts out with a petition, which is asking the court for what you want the court to do. So if there's a petition for guardianship, it means we're asking the court to appoint a guardian. And one of those questions, and they've got it highlighted on here, it's not on the first page in real life, but they've got it highlighted so you can see it on the slide, is if a guardian of the person's being appointed, there's 3 rights that you can ask the court to remove, or you will allow the court to keep in place. If the request is for the right to vote or register to vote, if the request is for that to be removed, this little box is going to be checked. If the box is left blank, then there's been no request made. Because again, the default is that we all have the right to vote. We don't have to do something with the court to make sure we have the right to vote in the first place. We already have that. But if there's a petition for guardianship, we need to look at that petition to see if that right to vote, if that box is checked, it means somebody's asking for it to be removed. All right, next slide. So who's going to decide? Now we know somebody has to petition for that right to be removed for that question to even be on the table. But the process is once a petition's filed, a judge or a commissioner, somebody sitting up on a bench, is ultimately going to make the decision about what goes in that court order at the end of the day. But how is that person making that decision? Well, the court's looking at their own judgment. They're looking at all the paperwork that was filed and all the information that was provided. But they usually don't know this person, right? They don't, if somebody is going to court and a guardian's being appointed, the judge probably doesn't know that person. They don't know a lot about them. So they're relying on outside information. They're relying on the report of a guardian ad litem, who I think Attorney Walrath's going to speak to later. The guardian ad litem, their job is to look at all this information and tell the court what they think is in the person's best interest. So in this case, is it in this person's best interest to keep the right to vote or to have the right to vote removed? They're usually looking at a doctor's report. If there's a guardianship ordered, there has to be a specific doctor report filled out that talks about what the doctor thinks this person can do or not do. And there are questions about voting on there. But we'll get back to that because a doctor may or may not be the best person to give an opinion on whether somebody can vote or not. Doctors are pretty good at healthcare stuff. They might not be experts at voting standards. And then again, the petitioner. So say mom and dad are asking for a guardian to be appointed for their 20-year-old son who's disabled. Mom and dad might be the petitioners. They're the ones asking for the court to appoint a guardian for their son. And that petition's going to say whether they're asking for the right to vote to be removed or not. Again, in Wisconsin, these forms are long. There's lots of boxes on these forms because there is not just one box that says take away all this person's rights. We go item by item because maybe somebody can't serve on jury duty, but maybe they can vote. We want that to be really customized to that person specifically. Okay, next slide, please. So, if you are subject to a guardianship proceeding or you're working with somebody who's in the middle of a guardianship proceeding and you want to make sure that right to vote is retained, that it's not taken away, there's some things we want to focus on. Generally speaking, even though a doctor might not be a real expert on what it takes to be able to vote, the court is really taking their opinion seriously. So if you are a parent asking for a guardian to be appointed for your adult child, if you're not wanting their right to vote to be removed, but the doctor's report says it should be, if I'm helping out, I'm actually going to talk to that doctor before I file that report. And I'm going to say, hey, are you sure about this? Because once that gets filed with the court's looking at that, even if you might disagree with it. Also, the guardian ad litem, they're sort of the person who starts out neutral, right? They don't have a horse in the game to begin with, so to speak. They're providing an opinion on best interest. The court takes their opinion really seriously. So you really want to talk to that guardian ad litem who's appointed on your case and make your position really clear because you don't want this question to get overlooked. My personal opinion on this after working on a lot of guardianship cases is that a lot of people might get their right to vote removed just because we overlook that box. People just don't give it a lot of attention. So make sure the doctor gives it attention and make sure that guardian ad litem gives it attention. Okay, next slide, please. So again, this is that order I was talking about. So the process of guardianship starts with a petition. That's what starts it. And then when everything's done, the court makes its decision and they sign an order. And that order is going to have a box, a little segment there that looks just like the petition that says, is this person losing their right to vote? So it's worded a little weirdly. You have to be careful. But if the box is checked by register to vote or vote, it means the right is being removed. If the box is blank, that means the person's keeping it. Because again, with guardianship, we're starting out with all of our rights. And the only rights that are changed are the ones that the court is specifically changing. And Lisa is telling me that I have a little bit more time than initial, so I'm going to try to not go too slow, but yeah, there's still some important stuff we want to go over here. So far we've been talking about how to keep us from losing that right in the first place, because that's really the best way to start out, right? Is we've got our rights and they shouldn't be taken away. But that doesn't mean that if the right to vote has been removed, that there's nothing we can do. We can fix that too if that's something that should be fixed. So that's what we're going to be talking about next, is how to get that right to vote back after it's been, and maybe it was removed correctly to begin with, but maybe we've improved in our abilities, or maybe it wasn't proper to have it removed at all. Either way. Next slide. So if we want to get the right to vote back, we've got some options here. First, we need to make sure that it's actually been removed. Again, a lot of people assume that just because you're under guardianship, you lost your right to vote. That is not necessarily true. If you have a copy of your determination and order, and if you don't have it, you can get it from the court. Or you can get somebody who helped out with your case. Look at that order. If that box is blank on that order, it means you are free to register to vote. That guardianship is not restricting that for you. But if it is checked, then we've got some work to do. So that's the next slide. Okay, so this gives us an example. If that box is checked on the order that says the right was removed in full, and then it has a checkbox next to register to vote or vote, that means you cannot go and just start voting. We need to change this court form first, and we need to go through a certain process to do that. It doesn't mean the guardian can vote for you. The guardian can never vote for you. It just means that you can't, but we can fix it if we do the right things. So that's what we're going to talk about next. Next slide, please. So how do you start? So these are the questions we'll go through. So I'm not going to go through all of those because we're going to answer those in the next slides. So let's go straight to the next slide. So you do have to go back to court. You can't just change the form. You can't just give a note to your doctor. You have to go to court to get it changed. There's a petition. Now, I know it used to be really hard. You really almost needed to use an attorney before, and there's still a lot of situations where an attorney is really helpful for this process because it is still complicated. I understand not everybody has those resources. There are some of these great agencies like the ones hosting today who can help put you in contact with attorneys, like myself and some of my colleagues who can look at these cases and may be able to help if all we're trying to do is get your right to vote restored. But you do have to go back to court, and there is a petition. Anytime we ask the court to do something, there's a petition where we're telling the court what we want. You do not need permission from your guardian. You don't need permission from the court ahead of time. You don't need to ask anybody if it's okay to file this. You just need to get the right paperwork filed. So you might need an attorney to help you with that. Next slide. You can absolutely have help. If you need help filling out paperwork or you need help with a court process, that's okay because the standard for voting is a lot different than the standard for filling out paperwork. I could need help with all sorts of different stuff and need a guardian for everything else on the guardianship paperwork, but I might still have the ability to vote. So don't be afraid to ask for help. That could be your guardian. It could be somebody like a family member or a friend, somebody who agrees with you and is willing to help advocate for you. Next slide. So like I said, you can obviously you can contact an attorney, and if you have the ability to pay, we are always happy to take those cases. But also, again, I think you will find that a lot of us attorneys who do this work feel really strongly about this. We can't take all of our cases for free. That's not the sort of firm I work. I run a firm and I have to pay people. But there are some of these cases where we can take some of these on a pro bono basis. So keep that in mind that if that's the only thing holding you up, try to reach out to some people who might be able to put you in contact. Also, you can ask the court to appoint an attorney for you. I think that very much depends on your county and the people working there, how easy that is to make that happen. Sometimes you can be waiting quite a while for that to happen. But in theory, you should be able to ask an attorney to be appointed for you. Next slide. Doesn't cost anything to file the paperwork with the court. Now, I understand it costs you time to fill out the paperwork and you have to go to a hearing and you have to do some work. It doesn't cost money to file the paperwork with the court. You don't have to have an attorney to file the paperwork. You just have to have the right paperwork filed. And it's going to be in the court where the guardianship is from. And you're going to know that because that determination and order that you were looking at has the county name right at the top of it. So even if you got your guardianship in Milwaukee County and then you move to Dane County, you're going back to Milwaukee County for that. Luckily, Milwaukee County does a lot of things online, but you're going back to the county where the guardianship was put in place initially. That's the court you're working with. Next slide. So the nice thing is there are some forms, and I think those links are going to be provided after this presentation, or maybe they were ahead of time. So again, it's a petition. What are we asking the court to do? And there's two different forms here. One is if the ward is signing it themselves, and one is if somebody else is filling it out for the ward. So the ward is the person who has the guardianship. I like to call them the individual, but the law calls them a ward. Um, you can sign the paperwork yourself. If somebody's helping you, that is also okay. Because again, needing help with paperwork does not mean you can't vote. Next slide, please. So a couple things I want to point out, not as much on this, but so it's going through and it's saying, you're the person who's under guardianship. You're asking your right to vote to be restored. It hasn't been right after another hearing. So they do make you wait a little while before you can ask for that right to be restored. So this is where it's important to make sure that that guardianship order is right in the first place. Because if your right to vote is taken away, the court does not have to hear from you again for another 6 months potentially. So you want to make sure that you're okay with that timeline. And then you're basically telling the court, you know what? I do have the ability to understand the objective of the elective process, and therefore I should be able to vote. So next slide, please. So the thing I want to point out here is that this petition, I'm glad the petition was put together because then you don't have to start from scratch. One thing I want to point out though is you should absolutely sign and date it and do all of that. But Wisconsin guardianship forms do not require a notary anymore for the vast majority of stuff we do. They used to require a notary. So if the only reason you're not getting your paperwork in is because you don't have a notary, I would say file the paperwork anyways, because really Wisconsin does not require a notary for most guardianship paperwork anymore, which makes it easier for you to get your stuff in because that's one less thing to do. So you file your petition and you ask the court to schedule a hearing. Next slide. So the court will schedule a hearing. They will appoint a guardian ad litem. There might be a doctor appointed. Usually the court is asking for you to come with your own evidence that you have the ability to vote. So you sort of want to do that legwork ahead of time. Eventually the court's going to look at the information you provide and they're going to have a hearing and make a decision. And I'm simplifying because we're almost out of time and we want to hear from other people. Next slide. So the court's going to tell you when the hearing is going to be. They're going to send you a piece of paper. You need to make sure that you are there or that somebody helps get you there. If you can't be at the court hearing, you need to tell the court that you need to do it virtually or they need to hold the hearing where you are. Otherwise, you got to get to the courthouse as well as anybody else you want to be there who you think is going to be able to help you out. Next slide. So a GAL or a guardian ad litem, again, is that person who's telling the court what they think is in your best interest. The GAL does not work at your direction. They are an attorney, but they don't represent anybody in particular. They are going to look at the information. So if you say you want your right to vote back, they're going to talk to you about it. They're going to look at whatever other information they can. So if you can give them good information on why you think you have the ability to vote, if you have other people who can tell them that, whether it's a friend or a guardian or a doctor, whoever it is, the guardian ad litem is going to look at all that evidence and then give an opinion to the court, and the court's going to take that pretty seriously. So we know that GAL doesn't work for us, but we really want to give them as much information as possible. Next slide. So again, you don't need to have a doctor. If you go to your doctor and the doctor says, I think you should have your right to vote restored, absolutely have your doctor write a note and give it to the court. If that's not your situation, you do not have to have a doctor opinion. Because again, the getting your right restored does not depend on a doctor deciding you can have the right back. The court just has to decide that based on whatever evidence you provide. So a doctor might be pretty good evidence, but that is not the only evidence that's needed. Next slide. So again, it's going to be a hearing is basically where you and the judge or the court official and the guardian ad litem and whoever else you want to be part of that is going to go tell the court why you should have your right to vote back. So you want to attend that hearing and you want to be ready to explain everything. And if you say, oh, my friend agrees with me on this or my guardian agrees, you want to make sure they are all there ready to tell that to the judge. Next slide. And then the court's going to make a decision. Do you have your right restored or not? If the court decides not, because maybe you didn't bring the right evidence or you just weren't ready or the court doesn't think you're there yet, then they will just deny your request and you can come back in a few months and try again. But if you're successful, and that's the really exciting part, is when you are successful and the judge says, yeah, I agree with you, then the judge is going to sign an order saying that your right to vote has been restored. Then you're going to get an order like that and you're going to want to hold on to that order. Because what you're going to want to do is one thing, the court should contact the elections board directly. So you shouldn't have to be providing that contact. The court should directly contact the election commission to tell them that you can register to vote, that you can be put back on the voting rolls. But you also want to keep that piece of paper that says that's true just in case. Next slide. Because in case they don't notify the clerk or in case they don't get that word to the elections commission, you want to have your proof too. As soon as you get your right to vote restored, you want to go and register. You do not want to wait until right before an election. Because now, if it is right before an election, then still try to go and do it. But you want to try to get registration as soon as possible because you want to make sure you have the right ID. You want to make sure the right paperwork's on file. You want to not wait until the last minute because if there are any kinks, you want to be able to sort them out so that you can actually vote on election day or so you can actually early vote. So just keep all of your paperwork and even bring it with you on election day, even if you think everything else has been done. Next slide. So I just want to spend a couple of minutes on sort of making your case, and then we'll open it up for all the other presenters. Because it can be scary. I'm still scared, and I've been an attorney for 15 years. It can be scary to go to court and to be in front of a judge, and how do you know what this judge is going to want to hear from you? Well, here's a thing to keep in mind. You don't have to pass any big, long test to be able to vote in the United States or in Wisconsin. You don't need to be able to name all of your representatives. You don't need to be able to recite a history book. The point is, do you understand the objective of the elective process? Do you know what an election is? Do you know why we have elections? Well, an election is where people get to go and choose what they want so that we can make a decision. You don't have to be an attorney or an expert at this. You just need to be able to tell the court, hey, like everybody else, I want to be able to go and vote for what I want for something. And that doesn't mean it has to be, president. It can be, I want to be able to vote for, my local village president. I want to be able to vote at some other election. You don't have to pass any sort of test. The idea is to understand what an election is and be able to explain that. I know what an election is. I know that I cast a ballot and that it's secret and that I can vote for whoever I want and that nobody else can tell me who I have to vote for and that whichever candidate gets the most votes wins. I mean, it sounds simple, but it's not a lot more complicated than that. You might just need some help telling the court that that's what you can do. Next slide. So I went over this already. You absolutely do not need to tell people who you are voting for. You do not need to tell people why you are voting for somebody. It's none of their business. And the idea is as long as you are the one who wants to do it and you have the ability to go and decide who you want, you should be able to do that. Next slide. So this is what's helpful, I think, because not that the court doesn't believe you, but if you go on your own, it's sort of your word against the court. If you can have, even if a friend agrees with you, if a doctor agrees with you, if your guardian agrees with you, if your caregiver agrees with you, the more people that you can have. Now, you don't need a whole committee, right? Any piece of evidence, that you can get is good enough. But if you have a bunch of evidence, bring all of it with you. Make it really clear. Because basically, most judges have absolutely no desire to keep you from voting, but they just want to make the right decision. So the easier you can make it for them to show them, oh yeah, this person totally should be able to vote, the easier you can make it for that judge, the more likely you're going to get that right back. And you can also have people write letters, even if they can't show up to the hearing. You can have them write notes or letters that you can provide to the court too. Next slide, please. I think this is the last one almost. Do we have one more slide? Maybe? Okay. So again, the court's going to make a decision. If it goes your way, that's awesome. Keep all the paperwork. You can now go to register to vote. Please vote in every election if you're able to. And there's lots of people to help you figure out how to get to the elections and when they are and how to get absentee ballots if you need them and all of that stuff. If you don't get your right to vote back, that doesn't mean you'll never get it back. You can try again. And that's where it might be good to bring in an attorney or some other helper to help you figure out what went wrong. But don't get discouraged if it doesn't happen the first time. That definitely does not mean that it's never going to happen. I've had people who were unsuccessful a couple times and then they did get it back. So it definitely does happen. And then I think the last slide, and then I'm going to turn it over because everybody's going to be tired of hearing from me by now. What do you do if you need help or you run into a problem? There's the voter hotline that DRW runs. There's the guardianship support system. There's a couple of links there. Again, I think my contact information may go out after this. You know, I am busy, but I will tell you, if somebody emails me and says, I need help figuring out how to get my right to vote back, if I can't help you, I will connect you with somebody who I think can, because there's a lot of attorneys who specialize in this, and we are all very excited about helping somebody get the right to vote back if we think that it's something that we're going to be able to do. So it's a lot of information. I think the slides are going to go out afterwards. Thank you guys for having me. I'm really excited about all of this. I'm going to stick around and listen to everybody else now. So thank you.
Thank you, Jessica. We do have a couple questions in the Q&A. Would you mind responding to those
Oh,
if we are
sure.
Jenny,
short on time?
Jenny, I'd actually like to hold and just hold those till the end, because I
Okay.
think there's a
Oh, no, I
possibility
didn't
that
mean out loud.
Monica
I
might
meant,
cover some information on that, maybe, or I just want to make sure that we've got time for our other panelists. So,
yeah.
Perfect.
all right. All right, thank you, Jessica. That was a lot of information. I'm glad that we had a little bit of extra time for you to talk through that. I'm gonna turn it over now. We have two members of our panel to talk through some of their experiences in this space. So I'm going to say welcome to Janine and Monica. They're coming into this conversation with different roles, but a lot of experience and expertise. So I'm gonna ask Janine if you are in a place to just share kind of a brief overview of how you have engaged on this topic and a little bit about what you've learned. And I would say maybe kind of 5-ish minutes, and then we'll have Monica talk, and then kind of we can work from what both of you have shared, and then have a few minutes at the end for questions. So if that sounds okay, I think that's how we'll move forward. So I'll turn it over to Janine.
Hello, can you guys hear me okay?
Yes, thank you.
Okay. All right. Excuse my fabulous appearance. I have been in the hospital since Monday the 20th with low calcium. So it's been an interesting ride. So Jade, that is why Jaden is not here. She is at home and wasn't able to do that. I guess I never, when we were doing guardianship for Jaden, I never occurred to me to think about voting. I'm not even sure how we came about that, but we did know about it before we met with her guardian at Litem. So we had talked with her. She had decided that she wanted to be able to vote. And when we met with her guardian at Litem, we did let her guardian at Litem know that, so that if that guardian at Litem had any concerns or questions, they could talk about them then. Then in preparing for the court hearing, we kind of helped Jaden practice or come up with how she was going to explain to the judge why she should have that right to vote. So we talked about our family is actually very dynamic. We have people from the far right to the far left. And we are a family that talks about politics. We have learned to talk politely, have discussion, things like that. So Jaden on her own came up with the plan that during elections, she would go and speak with different people that she knew who had different political beliefs. And they are allowed to tell her what their candidate will do for, the state, the country, for her, things like that. But her one rule is you cannot talk bad about any other candidate. So it's when you meet Jaden, it's a total Jaden thing. And honestly, I joke, I'm like, can we just like follow the child with brain injury damage? Like, what a concept. As far as deciding, like, I've talked with some parents and they're like, well, I don't know if they understand elections enough. I don't know that they do this. I guess my response to that is always, have you seen some of the man on the street interviews that people do? They will go out to college campuses. They're going to, city streets, and half the time, the average person who, is cognitive and competent and doesn't have a guardian can't tell you who the vice president is. So, I guess that's kind of my theory is if they know what voting is, they may as well have just as much knowledge as anybody else who votes. We do absentee ballots. So we have it sent to our house just so that we can put it out on the table. We can talk with Jaden about it. If she has questions, we're able to look up on the internet things for her. I let her do the initial, paper pencil marking of the ballot. I usually have to go back and just confirm that, things are dark enough or things are, the straight enough or however, that ballot is done. She's actually really gotten into it. She has spoken at city council meetings. She has gone and spoken to our mayor about potholes in the sidewalk. She just talked with our bank president about needing a automatic door in the bank. So I think voting has definitely helped her become more aware of what some of these agencies and what some of these roles do for us.
Thank you. Appreciate you sharing that, Janine. And thank you for being with us. My goodness, what a circumstance. And it's too bad Jaden wasn't able to join, but really, really appreciate you sharing that perspective. I'm gonna turn it over to Monica now. I think we'll come back and I'll have probably a few more questions for you, Janine, but I just want to make sure that we've got a little bit of time for Monica to share her perspective. The GAO perspective, and then I'll have a few more questions, and then we can do some of the questions in the Q&A. So I will turn it over to Monica.
Good afternoon, everybody. Everybody hear me okay? All right, so about 30 seconds of my background. Guardianship is a subject matter that's near and dear to my heart. I grew up with a sister who needed 24/7 care. She had a severe seizure disorder. She was nonverbal, needed all, ADLs, et cetera, provided by my parents. So I grew up in a household where this was definitely, something that I witnessed every day. At one point, my mother went to Madison to do some advocacy with respect to spending bills related to disability bills and things like that. That was decades ago. Also, my husband had a stroke 2 years ago, and thankfully he's made a really good recovery. But due to some paralysis in his lower right foot, we have had to go through the process of getting a car modified so that he actually has the ability to drive again. So when it comes to talking to individuals with respect to guardianship and how to meet all of the needs for their loved ones, I'm very passionate about it. Much like Attorney Liebau. she and I know each other. We've had cases where we've interchanged roles. She's been a guardian ad litem on a case. I've been the attorney and vice versa. So thank you everyone for having me. I do appreciate this opportunity. So I also worked with Waukesha County Corporation Council, and my office is located in Oconomowoc. We serve Walworth, Washington, Jefferson, Dodge, and Waukesha counties primarily. So because I have that internal knowledge of the Waukesha County perspective of filing these actions, the courts typically will look to a list of attorneys and they'll appoint us. And I know it's different for each county. And so, excuse me, I became involved, or I became aware of this organization when I was guardian ad litem on a case. And I want to echo many of the things that Jessica said, because she's right. The guardian ad litem can, in fact, give the court information that will be reviewed in an independent sort of way. So while I can't advocate on behalf of the person who's the prospective individual getting potentially placed under guardianship, I can, in fact, tell the court what I think is in the individual's best interest. So that means I need to speak with the people who are petitioning or asking for the guardianship. That would, be loved ones or parents. I have to speak to the individual themselves, and to the best of my ability, make sure that person understands the scope of the action and the fact that he or she does have rights to have, their opinion heard. Then I notify the court if that person is objecting to anything that's being recommended. So much like Jessica's presentation, she highlighted a lot of the rights that can be taken away or added or retained by the individual. So when I look at a case, I look at the physician's report, because we can't go into court without medical evidence of the need for a guardianship. So I'll look at that doctor's report and I will look at the rights that he or she has identified. I also will follow up with the petitioners or the parents or loved ones saying, hey, do you agree with all of this? And then I have to make a report that mirrors the rights that have been described in the petition and the rights that have been described by the medical professional. After I do my independent investigation, so to speak, of everybody involved in the case, I can then make my own specific recommendations with respect to those rights. So for example, if the physician is unwilling to amend his or her report that takes away the right to vote, but I have spoken with the family members and the individual personally, and I see no reason to take away the right to vote, my report can be different from the doctor's report, and then it's up to the court to decide. Also, I can't speak for all guardian ad litem attorneys, but when we get appointed, the first thing I do is I reach out to the family or the petitioners and I say, hey, tell me a little bit about this individual. I need to come meet with this individual. I want to know if there are anything, any special circumstances that I need to accommodate. For example, can I meet this person in the home? Is that the most comfortable setting for this individual? Or do you feel comfortable bringing that person to, my office or a, other agreed upon meeting place? If we have somebody that maybe I have behaviors that might trigger the individual, I want to know that. As an attorney, I talk a lot with my hands, so I don't want that to cause any fear or trigger any behaviors on that person's behalf. Also, I will ask for any sort of comprehension level needs so that I can make sure I am not just throwing a bunch of legal jargon into the conversation. I want to be able to make sure that individual understands the specific remedy that we are asking from the court. I then, by law, have to notify this individual that he or she has rights. So when it comes to, so-and-so, would you like to have this guardianship in place. I may not phrase it that way because nobody wants their rights taken away. So I make sure that I say, things like, hey, do you want so-and-so to continue to assist you with decision making? And then we kind of go through the general categories, etc. But I fear that not all guardians ad litem understand the significance of voting and the accommodations that can be made for people to vote. And so, I appreciate forums like this where we can educate the community so that they know they can reach out to the guardian ad litem and say, hey, let's specifically talk about voting. Or they can talk to the attorney who's helping with the case, or if they're in the courtroom by themselves, they can talk to the judge when given the permission to, and specifically say, hey, doctor's report says no voting, guardian ad litem says voting. We know our son or daughter or loved one wants voting rights. Interesting situation. There was a judge in a county, and he has since rotated out of the probate calendar that hears guardianships. But for a period of approximately a year, he was denying everybody a right to vote. I'm not going to name the county or the judge, but just automatically. And I had colleagues, again, we're all very passionate about this. So I had colleagues reaching out to me and say, hey, just so you know, Judge so-and-so is denying all rights. So we got kind of, a little bit more assertive in our request when we would go in front of this judge and say, hey, listen, our recommendations, whether it be guardian ad litem or the attorney, is, hey, I've met with this individual. There is nothing that's preventing this individual from being able to exercise his or her voting rights. So we made it very clear, kind of my colleagues and I, we tried to convince that judge that not just because there's a disability, right? Attorney Liebau did a perfect example of, we don't need to take any special classes to be able to understand voting. Or what the candidates stand for. So we tried to explain that to the judge, and thankfully he's rotated out. However, that put a lot of these families in the situation of what Jessica said, going back to court and asking for that modification. So it's a sticky issue. And like Jessica said, she gets nervous. I've been practicing 23 years. I still get nervous because we don't know what the judge is going to do. But that's how I approach cases as a guardian ad litem. I am independent. I make sure the people that I'm meeting with all understand that. Even if the person is nonverbal, I still go through the listing of their rights. They do have the right to object to the people who are trying to get guardianship. They do have the opportunity to have a trial in front of a judge or a jury. They have a right to have another physician examine them if they want the rights revisited. If they don't like that other doctor's reports, they also have a right to have an advocate attorney appointed for them. So that is the attorney who can voice that person's opinion. I can't do that. I have to determine or make a recommendation if the guardianship is in the person's best interest, and then address those statutory rights one by one and say whether or not it's in the best interest of that ward to retain those rights or have those rights taken from them. So that's what the role of a guardian ad litem is for each of these cases. And that's how I approach meeting with a family who is filing a guardianship action. Now, I would say that each county is different, and the people they will appoint as guardians ad litem. For example, one of the counties that I work with, they simply have 2 attorneys under contract, and they handle all of the cases. And so those 2 individuals are the only attorneys that you're going to get as guardians ad litem. They know the area of the law very well, but I don't know, how much time they spend with their ward, what accommodations they are willing to make, et cetera. So another point that I want to make sure people understand is be willing to reach out to the guardian ad litem. On occasion, people will show up kind of last minute. We are all very busy, and I'm not trying to throw stones, but sometimes people will show up last minute and do the guardian ad litem evaluation and make the report to the court. And we don't always see a lot of engagement with those attorneys. There has to be a confidential communication between the guardian ad litem and the individual. That being said, there's nothing that prevents the family members, either before or after that meeting, reaching out to the guardian ad litem and saying, hey, we just want to make sure you got information on these particular rights. You know, we saw that you met with the person, but we're not sure that he or she articulated it. And we want to make sure you understand that we've had that conversation with our loved one and stuff. So don't be afraid to, you know, politely and professionally reach out to the guardians ad litem. You know, they can't discuss much with you, but you can certainly, you know, advocate a little bit for things that are specific to your loved one's case. So, Lisa, you know, did that cover what you were looking for in terms of the difference between, you know, the attorney versus the guardian ad litem?
It did really well. Thank you so much.
Yeah, and one last point. Only attorneys can be appointed as guardians ad litem. No other professionals like social workers or even family members. It has to be a duly licensed attorney. So that was one thing I forgot. Sorry.
It's okay. Thank you. We are closing in on the scheduled time that we had. I did just want to note that for much of what has been discussed, we do have resources available. So we will send out the PowerPoint that Jessica went through. We do also have on the Disability Rights Wisconsin website, we have a whole page of resources that are really specific to guardianship and voting. So that includes information just about the law itself and its impact on the right to vote. It has a guide on how to get your right to vote back if you had lost your right to vote during the guardianship process previously. We have another resource that is how to keep the right to vote. So if you're going into a guardianship process or you have a loved one going into a guardianship process, kind of how to keep the right to vote on the front end. So lots of information there. Also want to just encourage, if folks are going have questions about this, please don't hesitate to reach out either to us at the DRW Voter Hotline or the Guardianship Support Center. We know a lot about this, and we know a lot of people who know a lot more about this, which is why we invited the panelists to chat today. I feel like we could go for another hour or two talking about this, so I apologize. It feels like we crammed a lot into this time. But please know that resources are out there. So if you have any questions, kind of if you are interested in kind of different perspectives or in whatever might help folks through this process, we would be happy to help facilitate making those connections for you. So in this last minute, I just want to acknowledge too, thank you to Jessica for answering the questions in the Q&A, really appreciate that. For both the folks who answer or who asked the questions and anybody who's interested in the responses, please check those out. And I think we hopefully can capture those and send those out in a follow-up as well. So we just hit 1 o'clock. I just wanted to ask if any of our panelists had any additional last-minute thoughts or things that they wanted to share. Janine, I also just want to say that in your picture that you just had up, you were wearing a Louise hat, and Louise is amazing, and I highly recommend it for anybody who makes their way to Cumberland, Wisconsin. So that's just a little random plug there. But any last minute thoughts as we wrap?
And an amazing disability advocate and supporter.
Oh,
they have a daughter, Heidi, who is I think maybe cerebral palsy, but in a wheelchair, and they do a lot with the disability community. So definitely a business to support.
Love that. Thank you. All right. there's no last minute thoughts, a huge thank you to our panelist presenters today. Thanks to everybody for joining us. Again, please reach out if you have additional questions or would like to have conversation on this. We are happy to do this kind of presentation for other groups, at least from a DRW and Disability Vote Coalition perspective. So reach out if you have anybody else that you think that this kind of conversation and information would be helpful for. So thank you so much to everybody who participated today, and we'll get information out to you about our forthcoming webinars soon. Have a great day, everybody.